Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 31st lecture series. Because of your support, because of Almighty's blessings, we are continuing with our lecture series, and this will continue for the simple reason that we have gathered here to enhance our knowledge, to equip ourselves to make the strong bar. Advocate on record examination is very important, but learning, continuous learning, even after becoming an AOR, it should be a life journey, and advocate on record is only the milestone in that journey. So continuous, we remain as a student of law. So before going to the topic, it is our regular practice that we recite preamble of the Constitution of India with a strong belief and faith that preamble our identity, preamble our divinity, preamble our soul, preamble our goal. So with this commitment and sentiment, I request each one of you to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now, moving on to today's topic. What is the procedure governing special leave petition in civil matters? And you all know, frequently asked questions comes from a special leave petition. There is no question which had never appeared. That means SLP, even in the practice and procedure also, as well as in the drafting also, it is very important as far as AOR examination is concerned. Apart from that, being a practitioner in the highest court of the land, you should know day in, day out, we draft special leave petitions, and most number of cases are filed through by invoking Article 136. So therefore, it is very important even for the practicing advocates also, apart from AOR aspirant. Now, how do we approach this topic? Because whenever, see, dear friends, this is not only preparation. Whenever you are asked to deliver a lecture, how will you make the audience understand, or how will you approach a particular topic where you have chosen to deliver? First and foremost is go to the root of the matter. That is very important. For example, if you look at a tree, if you want to narrate the tree, you will say roots beneath the soil, then stem, then branches, then fruits, and then shadow. And being a public interest, it provides shadow to the common man. Not only to the common man, any living creature who takes the shelter of the shadow of the tree. So that is how the overall view about the tree is concerned. Likewise, you can narrate everything in one go by looking at it, how you will explain to a common man. Because law is meant for the common man. This law man and law system, the judicial system, is existing for the public. Public is not existing for the law. Law is existing for the public. Therefore, justice is most important. So as far as this topic is concerned, how are we going to approach? Because I want you not only to be the listener, you should also be a speaker by approaching how sir is taking you to a particular journey, particular provisions. You should also travel along with me. because everyone are the masters. Here, though you may be listening to me, but you have all the potential of becoming master. Therefore, Lord Buddha, whenever he addressed his disciples, he never asked them like Shishya or student. He always addressed them as dear masters. Why? Because everyone has the potential. What I am delivering today, I must have understood my strength. Tomorrow you will understand your own strength. That is important. So the topic is how are we going to approach SLP, special leave petition, where it is dealt under the Constitution of India. Article 136 of the Constitution of India deals with special leave petition. How does it start? What are the how many clauses it has? It has got two clauses. Article 136 clause 1, Article 136 clause 2. Article 136 clause 1 says, notwithstanding anything contained in this chapter, which chapter? Chapter 4, which deals with union judiciary. The Supreme Court may, in its discretion, grant leave to appeal against any judgment, degree, determination, sentence or order. How do we remember exactly? We have to make a abbreviation, JDDSO. JDDSO, judgment, degree, determination, sentence or order, passed in any cause or matter by any court or any tribunal in the territory of India. So meaning thereby, an appeal, a special leave petition can be filed against any order. Any order means interim order or a final order passed by any court. They do not say specifically it is an appeal against the order of the High Court. Any court, maybe a district court, maybe magistrate court. Yes, even against the magistrate court's order, you can file special leave petition, provided you have to satisfy the Honorable Supreme Court why you have not approached the appellate courts. So any court, any tribunal in the territory of India, such a wide discretionary power given to the Honorable Supreme Court under Article 136. And coming to the second clause, 136 clause 2, it says it is an exception clause to clause 1. Reason is, earlier in clause 1 says when SLP will lie. Clause 2 says when SLP will not lie. Because when there is a judgment, determination, sentence or order passed by any court or tribunal constituted under the armed forces, special leave petition will not lie. So by looking at clause 1 and clause 2, clause 1 says when SLP will lie, clause 2 says when SLP will not lie. Clear, dear friends? Fine, we have read this. Now coming to the Supreme Court rules, now we have to ask ourselves this question. Where now we have understood special leave petition, but what is the rule which governs special leave petition? That is the second question posing to oneself. You can ask this question to yourself. The answer is Supreme Court rules. But how Supreme Court rules were framed? It was framed by the Honorable Supreme Court of India. Where does it derive its power? Because when the Honorable Supreme Court exercises its power to frame rules, where is the source of power? The source of power is Constitution of India. Which provision in the Constitution of India? Article 145 clause 1. What does it say? Let us see that. Article 145 of the Constitution of India deals with rules of court, etc. Clause 1, Article 145 clause 1 says, subject to the provisions of any law made by Parliament, the Supreme Court may, from time to time, with the approval of the President, make rules. Dear friends, with the approval of the President, the Supreme Court may from time to time make rules for regulating generally the practice and procedure of the court, including A. Rules as to the persons practicing before the court. B. Rules as to the procedure for hearing appeals and other matters pertaining to appeals, including the time within which appeals to the court are to be entered. C. Rules as to the proceedings in the court for the enforcement of any of the rights conferred by Part 3. That is writ petition. They are dealing with writ petition. In B, they are dealing with appeals. It may be a civil appeal, it may be a criminal appeal, or a special leave petition is also an appeal, extraordinary appellate jurisdiction. So, the Honorable Supreme Court derives its power from Article 145, Clause 1A and B, and therefore the Supreme Court rules was born. Now it is clear. Now we have come to the birth of Supreme Court rules. Now where do we get with respect to the special leave petition governing or related to the civil matters? Now let us go to Order 21, dear friends. Order 21 specifically deals with special leave petition in civil matters. On the last occasion, we have dealt what is when SLP is filed. We have said SLP is filed in two ways. For example, when you want to approach the Supreme Court or when you want to enter the Supreme Court, there are many gates are there. Gate E, Gate C, A, B, C is there. Like when you want to file SLP, how will you approach? Let us take an example. A High Court dismisses our case. We are aggrieved out of the High Court's order. We are not satisfied with the High Court order, therefore we want to prefer an appeal to the Supreme Court. I said SLP can be filed under two ways. The first way is we will approach the concerned High Court judge itself and we will make an oral application by saying that, my lords, please grant us, please issue a certificate under Article 134 capital A of the Constitution of India, because it involves interpretation as to the Constitution, it involves interpretation of, or it involves the substantial question of law concerning the general importance. So therefore it is a fit case to be decided by the Honorable Supreme Court. Therefore, your lordships, the Honorable High Court may issue a certificate under Article 134 capital A. So once certificate is issued, you can file under civil appeal. It is not special leave petition. Once it is denied, then you come to the Supreme Court. After the refusal of your certificate, you come to the Supreme Court under Article 136. The limitation is 60 days. So this is one way. What is yet another way? The second way is you don't approach the High Court at all. After dismissal, you directly approach the advocate on record and get your case filed under Article 136. You get the limitation of 90 days. So generally what we do is we directly file without seeking a certificate. So this is two ways to invoke special leave petition. Now thereafter, what is the format of special leave petition? Format is mentioned under form number 28 of the Supreme Court rules, because we draft special leave petition as per the form number 28. So this we have dealt in detail on the last occasion. Therefore, you can watch our previous videos. Now we will be starting with each rule after SLP is drafted, how SLP has to be accompanied. Still, we are still in the drafting only. How the list of dates, where the impugned order has to be filed, what is to be accompanied along with the special leave petition, how will you file an affidavit. Then if you are referring to certain relevant provisions of the Constitution or any other statutes or regulations, bylaws, the relevant provision has to be annexed. It is called appendix to the SLP. Thereafter only you will file the annexures. Annexures also you will give the name annexure 1, annexure 2. We generally write it as annexure P1, P2. But Supreme Court rule says annexure 1, annexure 2. And there will be a continuity of pages from 1, that is impugned order, and annexure is also paginated. Can you annex by saying those documents? It is a collectively. For example, it is all trial court records from the plaint till the trial court judgment. It is, can we say, a copy of entire trial court records is annexed as annexure 1? Can we do that? No, we cannot do it. Why? The reason is collectively is not permissible. We file annexures, we file index to those annexures for the simple reason, for the convenience of the court. If you file that entire record as annexure A1, then where is the question of what is there, whether there is a plaint, what is the page number, what is the written statement, deposition, then trial court judgment, then grounds of appeal. So everything will be in a very confused state, even to the counsel also who has filed it, as well as to the judges also. Therefore, for convenience of the court, as well as for convenience of the counsel, they have given a clear-cut procedure how to draft special leave petition in civil matters. So everything we will be dealing one by one. We will have to see, we will be dissecting each provisions, each rules by asking questions to ourselves. Therefore, we can have a better understanding. So I'm going to take you to Order 21, dear friends. Order 21, more particularly Rule 3(1)(a). That is, the petition for seeking special leave to appeal, special leave petition, filed before the court. We generally say SLP means special leave petition, but if you look at the rule says the petition for seeking special leave to appeal within bracket SLP, filed before the court under Article 136 of the Constitution of India shall be in form number 28. It is appended to the rules, Supreme Court rules. Now, no separate application for interim relief need be filed. The general practice is we file a separate application for stay, for interim orders. But in this case, in SLP is concerned, we will not draft a separate application for interim relief. It is already there in the special leave petition itself. So, no separate application for interim relief need be filed. Interim prayer, if any, should be incorporated in form number 28. Dear friends, I am not reading form number 28. It simply says, let me tell you, it is there, appended to the rules itself, form number 28. What does it say? Para 1, it has got 8 paragraphs. Number 1 is introduction, how you are approaching the Honorable Supreme Court, from which order, which is the impugned order, and the case details. Number 2 is question of law. 3 and 4 are declaration. 5th is the ground. 6th is grounds for interim relief. 7th is main prayer. 8th is interim relief. This is what they are saying. So we need not file any separate application. Interim relief is already there in special leave petition. Now, moving on to the B, 3(1)(b). Along with the petition. So now I am going to ask this question, dear friends. What is to be furnished along with SLP? This is a question. Whenever you want, you can even write a question, because our mind works when we ask questions. We cannot simply read it. So you have to ask questions. You write down the question there and then you read the answer. So my question here, what I have written is, what is to be furnished along with SLP, special leave petition, that is B. Along with the petition, that is special leave petition, list of dates in chronological order, in sequence, with relevant material facts or events pertaining to each of the dates shall be furnished. So framing of question should be such a way that what is there in the answer. So what is to be furnished? You have to furnish the list of dates and events, and it must be in chronology. When you're writing the story of our mother India, 15th August 1947, our mother India got independence. Then 26th November 1949, our constitution was adopted in chronology. 26th January 1950, we celebrate Republic Day in chronology. When you want to, you should not change the chronology. This is what they are saying. And list of dates, you must mention the list of dates. Corresponding to the list of dates, what are the events? List of dates and events. So along with the petition, list of dates in chronological order with relevant material facts. This is very important, dear friends. How do you determine what is relevant material facts? Because we all know what is the fact. Whatever it is happening, that is the fact. For example, if somebody asks you, or if your friends or any other AOR aspirants who has not attended this lecture today, when you're stepping out, if they are asking what sir taught you, what you have learned, I went there, system was kept there, this flask is kept there, and videograph is going on. Do we say all this? Though it is a fact, lights were turned on, fact. They will say, we all know this. What is the material fact? What is the purpose of your attending the class? What have you learned? Then you will say, Article 136, yes, that is a material fact. Order 21, material fact. So we have to narrate only the material facts, but client will not know what is material fact, because according to him, all is material fact. So we are the one who has to filter it, material fact from all the facts. So therefore, dear friends, when you are narrating the events also, in transfer petitions, they might have lived for 10 years, but we cannot write all 10 years happenings. We will be saying marriage took place, out of the wedlock children were born, due to the difference of opinion, after 3 years or after 5 years, due to the difference of opinion, case was filed. Simplify, because the purpose is to get the transfer, what is relevant to allow the transfer petition, that alone we will state. Otherwise, every day what they had, we cannot state all those. That is not relevant facts. So list of dates and events must pertain to the material facts. Now, second one is C. Now, the question is, can we urge additional grounds in SLP? I request each one of you, if you have the rules, you can write it in pencil. Can we urge additional grounds in SLP? That is the question. The answer is, special petitions shall be confined only to the pleadings before the court or tribunal whose order is challenged. When you are challenging the High Court order, so whatever the grounds that you have urged before the High Court, those grounds alone you will take it before the Supreme Court. Because you will tell to the Honorable Supreme Court, you will respectfully submit to the Honorable Supreme Court by saying, these are all the material facts, grounds I have urged before the Honorable Supreme Court with supporting documents, but the Honorable Supreme Court committed perversity. This term repeatedly I use in every lectures for the simple reason, dear friends, Article 136, if you want to open that Article 136, the key is the perversity. What is perversity? Now the question is, what is perversity? It is very beautifully worded in one of the judgments. Improper reception or rejection of vital evidence. Improper rejection or reception. That means what? The Honorable Supreme Court did not consider the relevant facts or material facts. In other way around, we can say the Honorable Supreme High Court considered the irrelevant facts, not the relevant facts. So what is to be considered that was not considered? So therefore they have committed perversity. Therefore the Honorable Supreme Court must interfere under Article 136 to provide justice, to prevent miscarriage of justice, to advance substantial justice. So if that being the position, question of law we can urge at any point of time, because substantial question of law we must urge in the Supreme Court considering the facts and circumstances. But with respect to the facts are concerned, grounds are concerned, that you must always confine to those pleadings which you have urged before the courts below. But there are exceptions also. Let me read this and let me explain. Especially petitions shall be confined only to the pleadings before the court tribunal whose order is challenged. However, that means it is an exception. The petitioner may, it is not shall, may, with due notice to the respondent. That means whatever you file it, you please serve him the other side. Because what is there? Complaints of natural justice. Audi alteram partem. You hear the other side. You will not let the other side to take an aback, to take a surprise. You should know what are the material facts, that additional grounds that he is urging before the Honorable Supreme Court. That has to be, notice has to be served. And then with due notice to the respondent and with the leave of the court, with the permission of the court, urge additional grounds at the time of hearing. So you can bring additional grounds which you have not taken. That's the reason we move a separate application, an application seeking permission to urge additional grounds. Because ultimately, dear friends, we must know one thing. Though the rule says we cannot take additional grounds, but these are all only the procedures. For what purpose? To provide justice. If an advocate has failed to take any grounds before the High Court, any material grounds or facts which was not brought to the notice of the court, but you have found out. Now the rule says you cannot urge any additional grounds. Are you prevented? No, you have an exception. Because procedures are the handmaiden of justice. Technicalities should not come on the way to when we are advancing the justice. So justice is paramount. The procedures are only the format. We all know that writ petitions, how they are entertained, and the rules deals with writ petitions. Then how a letter is treated as a petition? A letter petition is treated as a PIL in many cases. The reason is we are not concerned with the form, because in those PILs, the honorable justices have said we are not concerned with the form, we are concerned with the justice. So therefore, dear friends, most important is, if you want to urge any additional grounds, you can do that. Nothing will prevent you, because we fall under the exception clause. Because on the last occasions, I have dealt with one of the cases, Raja Bhaiya Singh case, where he was convicted to life imprisonment both by the trial court as well as by the High Court. Later on, I found by reading the trial court judgment, in the cause title it was written, Raja Bhaiya Singh, aged 17 years, appears to be 21. So we all know that below 18 years, he is a juvenile and he cannot be tried by the trial court. Then how he can get the life sentence? So we ask that additional ground. Because I cannot say we are prevented from urging additional ground, let him be there in jail. We have a window. We may not have a door, but we have a window to say that this is an application which we preferred, and ultimately he was acquitted. Though those grounds were not urged even before the trial court or before the High Court also. So therefore, dear friends, to advance substantial justice, the entire system is functioning. The people of India, if they have any grievance against the legislative, against the executive, they will come to the judiciary. If they have a grievance with respect to the judiciary, where will they go? We are part of the system, and the bench is our bar is considered to be mother of the bench, because all the honorable judges, they were once members of the bar. After becoming an advocate, after having rich experience, they were elevated to the dais. So therefore, when we are making, this is a continuous process of making the strong bar. Therefore, it will produce strong bench also. Ultimately, who is the beneficiary? Beneficiary is the people of India. That is what we, the people of India, just as social, economic, political. So, dear friends, even we look at when we travel in a car or we travel in a metro, we see children selling the roses, maybe below 14 years, below 17 years. At that time, we ask ourselves this question: where is the fraternity assuring the dignity of the individual? So that means we have not worked because we are a privileged community. We are a leading profession to lead other professions because we know the law. So we have to be very effective, efficient, and we must understand the glory of this profession, and we should be very strong, dear friends. Swami Vivekananda says that if there is sin in this world, there is only one sin, that is underestimating yourself. You cannot say, I will not be in a position to do it, or I am not capable of doing it. I don't have that potential. This is the only sin that you are committed. That this is the only sin that you are committing. You are born to achieve. You have all the potential. Only thing is you are thinking that you are a rat, but you are a born lion. This is what Swami says. Swami Vivekananda says. Now coming to, dear friends, however, the petitioner may with due notice to the respondent and with the leave of the court urge additional grounds at the time of hearing. Now D1, dear friends. What is D1? What are the petition or documents filed along with the SLP? This is the question that I framed. What are the petition or documents filed along with the special leave petition? Now we are going to see the answer. The petitioner may produce copies of such petition or documents which are part of the record in the case before the court or tribunal below, and to the extent necessary to answer the question of law. Dear friends, please mark this line. Question of law arising for consideration in the petition or make out the grounds urged in the SLP. So you are going to file relevant documents. For what purpose? For two purposes. Firstly, you will support your annexures must support the question of law which you have urged, and it must support the grounds which you have urged. It must answer, the supporting documents must answer to the question of law. So you must always file the necessary documents. You should not file whatever the documents you have. You must choose those files. You must choose those documents which are only necessary to answer the question of law and to support the grounds that you urged in the special leave petition. Ultimately, our destination in the SLP is the prayer. We need leave to be granted against the impugned judgment. That is our destination. These are all the journey. Question of law is a one journey. Thereafter, grounds is one journey. Then interim relief, then main relief. We are moving towards. So any documents that you support, that must push you, take you to the destination. Or you must create such a situation where the Honorable Supreme Court in a position to grant you relief, because you have got enough grounds, supported with facts, supported with documents, then there is no other option except providing you the relief. So it is a journey of SLP moving towards the destination, that is the prayer. These are all the different stations. SLP, raising question of law, declaration, grounds for interim relief, then main relief, and then interim prayer, right? So therefore, dear friends, whenever you file the documents, you must ask yourself whether this document is going to answer the question of law. No, drop it. Or otherwise, you can ask one more question. Does it going to support your grounds? If it is yes, file it. Otherwise, you need not file it. Now, thereafter, the next question is, to what extent, as annexures, how to number it? That is next question. how to number the annexures? We generally annex in the specially petition annexure P1, P2. If you are moving any application, we say it is A1, A2. If respondent files any documents R1, R2, it goes with the nomenclature. But here, this Supreme Court rule says annexures to the petition, that is specially petition, numbering them as annexure 1, 2, 3 and so on. The documents filed as annexures shall be arranged in what order? Chronological order. In sequence. You cannot file directly the High Court order or High Court document first and then trial court next. You should always follow the sequence, chronology. And the documents shall not be indexed collectively. Just now I have said, you cannot say the complete record of the trial court is annexed as A1, complete record of the High Court is annexed as A2. That should not happen. You should always name or give annexures to each document. Plaint, written statement, deposition of PW1, PW2, annexure 3, annexure 4, like that. It should not be done collectively. We say COLLY, COLLY, but that is not permissible under Supreme Court rules. The documents shall not be indexed collectively, and each document shall be indexed separately. The petition, where it refers to annexures with annexure number, shall also indicate the page numbers. Next, if the petitioner wants to produce any documents which was not part of the records in the court below, he shall make a separate application stating the reasons for not producing it in the court or tribunal below and the necessity for its production in the court, and seek leave of the court for producing additional documents. The question here is, when can you file additional documents? Just now we have seen when can we raise additional grounds. This D2 says, when can you file additional documents? So generally we have to file those documents where we have already filed before the courts below. But when you are first time filing it in the Honorable Supreme Court, then you have to give 2 reasons. What are those reasons? You will say, what prevented you from filing it before the courts below? And what is the necessity for filing it now? You will say, earlier it was not discovered. Like juvenile, as a Rajabhaya Singh case, we have not found it. But now we are making it as additional annexures. What is that? SSLC certificate, 10th certificate. Therefore, it will show the date of birth. So it is a SSLC or 10th mark certificate is very, very important to say that he was a juvenile. Next, the English version, whenever you file any relevant provisions, when you are referring to any of the provisions, appendix has to be filed. So if you are referring to, for example, 145 of the Supreme Court rules, you will narrate what is Article 145. This is for convenience of the court. We are doing it. Now, dear friends, now E. Every petition shall be supported by the affidavit of the petitioners. Now, there are more petitioners. Nearly 10 petitioners are there in the SLP. Who will sign in the affidavit? Whether all 10? The rule says yes, if all 10 is there, they can do it. There is no difficulty. SLP accompanied by 10 affidavits. Or one petitioner filing on behalf of remaining 9. This is one option. Yet another option is, though he may not be a party, but they will authorize some other person to sign on his behalf. So let me read, dear friends. Every petition shall be supported by the affidavit of the petitioners, plural, or one of the petitioners as the case may be. So one petitioner saying on behalf of others, or by any person authorized by the petitioner, in which the deponent shall state. So any person can file when he is authorized to depose the affidavit. but what they need to state in the affidavit, in which the deponent shall state the facts stated in the petition are true. Because as an advocate on record, being in the Honorable Supreme Court, how will you know what has happened in the matrimonial life? How will you know that his property was taken away? So whatever the input that client gives to you, you cannot be made accountable for the false statements, because you are acting on behalf of the client. You are an actor, but who is the director? Director is our client. So therefore, dear friends, he has to be made accountable for any statements. So the facts are, deponent says, shall state that the facts stated in the petition are true, and the statement of dates and facts furnished along with the SLP are true to his knowledge and or information and belief. When it is well within his knowledge, it is well and good. But if it is a departmental matter or a company matter where directors got changed as per the information and belief, because he perused the record and he says in the year 2020 some other director were signed, so therefore he will say that because of the information and belief, though it may not be within his knowledge, because he was not there at the time of transaction. So because of perusal of the records, it is his information and belief that he believes that it is a true statement. This is very, very important, dear friends. This, you have to, we can write thesis, in my humble opinion, we can write thesis on this E point. Why do I say so? In my respectful submission, whatever the petitions you file, that has to be accompanied by an affidavit, because you are making the client accountable for his statements. It is a settled proposition of law that whenever a litigant approaches the honorable court, any court, he must approach the court with clean hands. He should not suppress the material facts. He should not give misleading statements. He should not play fraud upon the court. Otherwise, he is not entitled to be heard on merits. He is not entitled to any relief, be it interim or final. This is what the Honorable Supreme Court judgment says in Kishore Samriti case. So in our case, when a client gives a false statement, it is also punishable under IPC. Now BNS, giving false evidence. Giving affidavit is also a part of evidence. So when they are made accountable, where is the procedure for initiating under perjury? That is 340 CRPC, old 340 CRPC. Now please find out the corresponding provision in BNSS, Bharatiya Nagarik Suraksha Sahita 379. So in my humble opinion, dear friends, there are so much false statements are made in the petitions with no fear of penal consequences. If it is made strict, we can prevent unnecessary frivolous cases. Therefore, our time, advocates' time, court's time can be spent on the genuine cases. If we say that if any falsehood is proved before the court of law, he will be deprived of his livelihood, he may lose his job, he may have the fear of going behind the bars, then who will dare to make false statement before the court? When I was listening to one of the interviews by our esteemed senior advocate, Mr. Harish Salveji, he has said, when there is one point of falsehood in the petition which is filed before the courts in London, they will throw it, because you are not entitled to enter inside the court. They will throw the petition with heavy cost. Therefore, when they have only genuine cases, they come. Here, when we say that it is full of falsehood in the court of law, it should be decided then and there, and it should be decided, and it should be disposed of. But here, what is the position is, we will hear it along with the main petition. Then where is the question? Why should he spend almost 10 years to say, oh, he is innocent? What is to be decided after 10 years? Why not today? Within 3 months we can dispose of. Because perjury is supported with documents. So therefore, in my humble opinion, dear friends, though I I have done PhD law in judicial delay only with respect to docket explosion of special petition. So one of my finding is the litigants has no fear of perjury, has no fear of penal consequences. They make all statements and finally at what they will say, we will withdraw the petition. Once it is withdrawn, that's all. Of 10 years has gone. Where is the right to precious time? It's high time to recognize the precious time of every litigant. Because time once lost, it is lost forever. He has to be compensated. When he says, when he fights his case for 11 years, and then he says, it is disposed of or it is dismissed, what about his 11 years? Then he has to file suit for damages. That will go for remaining 11 years. So therefore, dear friends, to provide substantial justice, falsehood is the one and only solution. That even there is a fear of penal consequences, we can prevent the judicial delay. Only if genuine cases will come, it will cut short all the frivolous cases. Therefore, lawyers also can spend time and judicial system can provide speedy justice, timely justice when it guarantees a fundamental right to recognize that we have a valuable time, right to time. Should also be implicit in Article 21. That is my humble submission. So with this, it will be a lecture series. So this is good for today with respect to the governing SLP in civil matters. Now we will take few more minutes for other topic also, dear friends. So thank you so much with respect to this.